Oh, let me let them know. I did say that. Yeah, I did say that. I'll definitely provide. Yeah. There's some kind of freedom. into the commission. Yeah, I mean, there were one or two things I wanted to change, but we can do that afterwards. I'll tell them the same thing, but after we will circulate it afterwards. Yeah. But I mean, I'll use it now orally. Yeah. absolutely relevant because the decision that has been taken by the SA Chauke to that decision had been taken by the court order. Yes.
Good morning, everybody. Good morning, everybody. Good morning, Chauke.
Morning, Chair.
Good morning, Advocate Andrew.
Morning.
I didn't see you this morning.
Yes, but I was told that there was confusion about the blue lights. Everybody thought they were mine. But it turned out that they were for the panel.
I told her it's important people like you who use blue lights. Yes, we received your apology.
Thank you, Chair.
Yes, thank you. We may start where we ended yesterday.
Thank you, Chair. Could I start by handing up we've got 3 bundles we'll be making references to. The only reason we are doing this, some of them are already in the record, but it's because of the state of the record that we are extracting from it. In the course of our, we could start then the opening address. We say that Mr. Chauke are denied. They are unfounded. In fact, they are unsustainable in law. They are based on a grave misunderstanding. The decisions that he made, the decisions that he was empowered to make, and most importantly, they overlook judicial pronouncements. They are also dangerous charges I don't say that lightly. What Mr. Chauke is accused of is not dishonest, is not corruption, is not malafide. He is accused of exercising a prosecutorial discretion in a particular way. It is extremely dangerous to charge a prosecutor for exercising a discretion in a particular way. That is why everywhere you go in the world, prosecutors are never disciplined for exercise of a discretion. They are disciplined only when they act malafide. When all of the charges, you will find that they are also vague and embarrassing, and they don't disclose an offense because there is not a single reference to the fact that Mr. Chauke exercised his discretion in a that exhibited ulterior motive or gross recklessness. And I don't want to sound dramatic, but take an example of a judge who makes a decision that is outrageously wrong because it completely ignores the facts. To charge that judge of misconduct in removal proceedings would be a grave assault of the judiciary. What you always need something extra, that when the judge gave that judgment, he was motivated by malice. And that is what will distinguish a bona fide exercise of a discretion with a malicious conduct by a judicial officer. Now, of course, NPA prosecutors are not judges, but their independence is protected by Section 179 of the Constitution. And the reason we say that these charges are also dangerous is because they threaten to interfere with the independence of prosecutors. And that is more so because in this case, the person who has called this is the president capacity as the head of the executive.
Might I, Mr. or rather, Advocate Andrew, don't want to interrupt you. I'm not sure whether the example or the comparison of a prosecutor and a judge is the correct one.
Yes.
Say, for instance, if a judge is found to have grossly misconducted himself or herself,
Yes.
there's a great possibility of such a judge being removed from office.
Yes.
Because of the gross misconduct.
Yes.
Supposing the allegations here are found to be or to constitute a serious misconduct,
Yes.
will the charges then be found to be founded in that event?
Yes, there's no doubt about that. We agree. But what you will see, which is why we've copied the terms of reference, that Mr. Chauke is not charged with gross misconduct.
But if you look at the charges themselves, if I refer to them as the charges, the terms of reference, supposing you equate them as constituting serious misconduct, if they are found to constitute serious misconduct, this allegations,
Yes.
if they are found to be true or correct,
Yes.
and found that they constitute a serious misconduct, will such charges be founded you say that they are vague and embarrassing.
Yes.
But if it is found, just on the reading of the terms of reference as they stand, and it's found that these allegations, if found correct, are serious, it constitutes a serious misconduct, can you safely say that the charges or allegations are unfounded on the evidence that will be presented?
No, there are two questions, Chairperson. The first one is that we say on the facts they are unfounded, in which event we don't even go to the second inquiry.
You don't go to the seriousness.
Yes. Thank you. Now, the point I had just completed is that it is extremely dangerous to charge a prosecutor for the exercise of a prosecutorial discretion, whether that discretion is a discretion to institute a charge or a discretion to withdraw a charge. To elevate that into misconduct is extremely dangerous in South Africa. One of the witnesses, we will be calling Mr. Geriner, will explain what impact on the ability of prosecutors to make decisions. They must make robust decisions in difficult environments with uncertain facts, in circumstances where they don't have enough support from the police and where accused persons are severely legally armed. Prosecutors make many decisions. Those decisions are usually imperfect. But if you start a pattern where you say to a prosecutor, I'm sorry, I disagree with your decision, but I am also going to initiate removal proceedings. That is an extremely dangerous thing. Prosecutors would be so reluctant to make the decisions that we want as a country for them to make. And we don't mind when they are found by the judges to have been wrong, that an accused is acquitted, because we want them to fulfill what the Constitution requires them to fulfill. So there is a level of thoughtlessness that underpins the request for the President to charge Mr. Chauke for the exercise of the prosecutorial discretion, because its consequences in a country that is besieged by crime are
actually very, very serious. So that is by way of a broad outline. I'm still going to go to the individual instances. The second thing to be said about these charges right now is that the factual premises of these charges have been overtaken by judicial authority. They are judgments that are pronounced specifically on whether or not the NPA was rational or irrational in its decision to charge Mr. Boyson for racketeering, or its decision to provisionally withdraw the charges against Mr. Nduli, subject to an inquest under the Inquest Act of 1959.
And if I may, just for clarity, this theme that you are now addressing, that these events have now been overtaken by judicial pronouncement, does it relate to both?
Both.
And then
Both of them, yes. So if we start with the judgment of the Boyson matter, Now, the panel will recall that what this relates to is that in the late 2000s,
The judgment, I'm sorry to
Yes.
interrupt you, I just want clarity so that we get it in why.
indeed,
The Katomena Boyson's letter, the judgment there is the KZN decision of the High Court.
yes, by Judge Gordon.
Judge Gordon.
Yes.
So you are referring to that, not the SCA,
No, I am referring to
the High
both
Court.
the judgment by Judge Gordon
Yes.
as well as the judgment. So the judgment by Judge Gordon is reported as Boyson versus acting National Director of Public Prosecutions.
Yes.
And it's reported in the 2014 Volume 9 BCLR 1064. It's a KZN. But even that judgment has itself been subject to further judicial pronouncement in a case called the General Council of the Bar of South Africa versus Jiba and others. The judgment of the full court, and the person who wrote the judgment of the court is Judge Napoli. There were 3 judges. It's reported in 2017, Volume 2, SA 122 GP. Now, why this judgment is crucial, that if the court will remember, the General Council of the Bar applied to strike Ms. Jiba from the role of advocate on a range of allegations. One of them was the signing of the certificate under Section 2 of POC relating to Mr. Boyson. The GCP relied fully on the judgment of Judge Gordon. The full court reviewed all of the evidence, and it ultimately came to the conclusion that Ms. Jiba acted rationally when she instituted the racketeering charges against Mr. Boyson. There are several parts of that judgment which are crucial for the court to keep in mind right now. The discussion on Boyson, on Mr. Boyson, starts at paragraph 41. And then it goes on to paragraph 67. But here are the most important observations that were made. I'm not criticizing my learned friend for the state, but with respect, he did not read these paragraphs. Unfortunately, in inquiries like this, it's not just the evidence against Mr. Chauke that should be taken into account, but it's also exculpatory evidence. If you have regard to paragraphs 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65. I want to read 66 and 67 into the record of the full court judgment. It says the essence of the information before Jiba can be summed up as follows. In addition to what is stated in paragraphs 56, 57, and 60 of this judgment, Boysen was the head of the Katamano Organized Crime Unit in the South African Police Service. Members of the police in his unit and under his command had allegedly committed crimes of a serious nature, including murders against suspects who were sometimes framed in the commission of offenses. Boysen knew, approved, and or ought to have known of the commission of these offenses. In regard to the members' unlawful activities, Boysen motivated for an incentive of 10,000 rands each for the 26 members of the Ketomano crime unit, including Boysen himself. Boysen was also commended for outstanding services rendered in that he was part of a team who, through their commitment and dedication, arrested several crime officers. Madam Chair, this is the full court summarizing the information that was before Ms. Jiba at the time the decision was taken. Paragraph 67. I cannot find any malafides or ulterior motive in the authorization by Jiba as contemplated in POCA. POCA is like a cry out for a declaration of war against serious, continuous, and organized crimes. That needs special investigation and prosecution. Most importantly, POCA requires the freedom and space to be given to the members of the prosecuting authority in the exercise of their legislative power to investigate through members of their investigative directorate and under the watchful eye of the special director so appointed to prosecute without fear, favor, and prejudice those implicated in the commission of serious crimes. Anything short of this, or anything which tends to impede on this constitutional and legislative imperative, for example, howling Jiba to the proceedings in terms of Section 7 of the Admission of Advocates Act, ought to be based on very cogent, serious, and exceptional circumstances. Paragraph 68. You do not want members of the prosecuting authority to unduly watch their backs for fear of being dismissed or removed from the role of advocates every time when they make mistakes in prosecuting or presenting cases in court, or every time when an application for authorization is made in terms of Section 2, subsection 4 of POCA. An overriding factor for them for consideration should be to adhere to the rule of law and the Constitution. It suffices for now to conclude on the Boysen matter by stating that no case has been made for the removal or suspension from the role of advocates. I turn now to deal with the other matters. So, come back to this point, Madam Chair. There is clear judicial authority that Ms. Jiba acted lawfully based on the information that was before her at the time that she authorized the racketeering certificate under Section 2 of POCA. That judicial authority goes further to warn that it is a dangerous thing for prosecutors to be dismissed or removed from the role of advocates when they have exercised that discretion in good faith, even if one comes to the conclusion that that discretion you think you should have exercised differently in the prosecutor. What is also important about that judgment is what is contained in paragraph 63, which is really the essence of what the case against Mr. Chauke is. Which is, what is the standard of the evidence that must be present in the docket for the authorization of a racketeering certificate? That has been answered by the High Court. It has said the following. In my view, the provisions of Section 2, subsection 1, E, and F, referred to in paragraph 44 of this judgment, are meant for the criminalization of such activities. The point I am making is this: courts, for the purposes of an exercise of its discretion in terms of Section 2, subsection 2, referred to in paragraph 62 of this judgment, may rely on hearsay evidence, information, and/or documentation collected by the police and presented to it by the prosecution. If that is so, and the courts are entitled to have regard to hearsay evidence during the trial, so too should the National Director of Public Prosecution, JIBA in Boise's case, be entitled to rely on hearsay and similar facts evidence for the purposes of authorization as contemplated in subsection 4 of subsection 2 of POCA. Otherwise, pervasive presence of criminal gangs will continue to rule with impunity and fear in many of our communities, and resultantly pose harm to the well-being of many communities. So that's also going to be a central feature of our case, that at the time a racketeering certificate is authorized, the nature of the information that must be present is broader than the evidence that the evidence data suggests in this inquiry. It includes hearsay evidence, information, and documentation. That judgment, Madam Chair, was affirmed by the Supreme Court of Appeal in Thank you, Madam Chair.
Advocate Andrew Chauke, I suppose somebody will be able to account. Somebody, the mountain over there.
In my village, they would have blamed an evil spirit.
The floor is very slippery. I am okay, thank you.
Thank you, Chair. I wonder if there's something they should be doing to make you more stable and comfortable, Chair.
You would actually be surprised we moved the junior chair that was here because it was more problematic.
Oh, that's. I'm happy that we continue.
Yes.
Thank you, Chair.
So this agenda is in front of me. He's taking note of this. Yes.
So now the judgment of.
I'm sorry for the interruption. Addressing the aspect of the similar facts evidence and the hearsay aspect.
Yes, I was, Madam Chair. So I was referring specifically to paragraph 63
Yes.
of the GCB versus JIBA judgment, which specifically denounces the approach that has been adopted in the opening address of the evidence leader. Now, that judgment of GCB versus JIBA was also taken on appeal before the Supreme Court of Appeal. And you will find that in item 2 and 3 of our bundle, particularly at pages 8 to 36. Yes, I'm corrected that the JIBA one is item 3, page 37. The important paragraph there is at page 44 of the bundle. This is how the Supreme Court of Appeal disposed of the Boysen situation. It said the first complaint dealt with by the court of appeal was in connection with the Boysen's case. In that case, Jiba, in her capacity as acting NDPP, issued 2 authorization letters charging Major General Johan Wessel Boysen with the contravention of Section 21E and F of the Prevention of Organized Crime Act 121 of 1990. In a nutshell, Boysen alleged that when she asserted that she considered statements together with other information in the docket before she took the decision to charge. This allegation was further exacerbated by the negative remarks of Governor J, who presided in the Boysen matter, when he drew an inference that none of the information upon which Jiba relied linked Boysen to the offense in question. The court of appeal, now this is now referring to Judge the Khodi's judgment. The court of appeal that it suffices for now to conclude that on the Boysen matter by stating that no case has been made for the removal or suspension from the role of advocates. I do not find it necessary to deal with the detail of the complaint of the finding of the court of appeal. I share the sentiment expressed. Before, as counsel for the GCP, dealt with some of the complaints, but in my view, did not take the matter any further. The court of appeal could not find any mana fide or ulterior motive in the authorization by Jiba as contemplated in Hawker. So the point is, the Supreme Court of Appeal, in express terms, endorsed the findings of the High Court in relation to whether at the time of the authorization there was sufficient information before Ms. Jiba. That case went to the Constitutional Court. It suffices only to say that the Constitutional Court rejected it for absence of jurisdiction. So the final word is the paragraph 10 of the SCA judgment, which found in express terms that the judge was correct in saying that we do not want prosecutors to fear being disciplined when they make bona fide decisions under Section 2 of OCA. Now, Madam Chair, why have I been talking about Ms. Jiba and not Mr. Chauke? If you take the terms of reference and specifically you start at page 3 of the bundle that we've handed out, and you go to item 3, and particularly 3.1.1, it reads as follows. The institution of the racketeering charges in terms of Section 2.4 of the Prevention of Organized Crime Act against Major General Boysen and members of the Cato Manor, and the defense of those actions in subsequent review proceedings brought by Major General Boysen to have the racketeering certificates set aside, in that he, Advocate Chauke, in other words, the case against Mr. Chauke, 3.1.1.1, supported a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. And he sought to improperly have the acting director of the Public Prosecutions of KwaZulu-Natal sign the case dockets and or the prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made. So the case is that Mr. Chauke merely supported a decision. He did not take the decision. That is because it is common cause that the decision was taken by Ms. Jiba. And Ms. Jiba, according to the GCB case had sufficient information to prosecute Mr. Boyson. We ask, therefore, rhetorically, if the decision maker acted without mala fide, acted lawfully and rationally, and acted in circumstances where they may not be disciplined or dismissed or removed from the role of advocates, how can the person who merely supported the decision be charged with misconduct? Now, the evidence leader knows that this is a problem. That is why he then tries to introduce the findings of the Judge Mohoro panel. But he faces two fundamental problems. Those findings are not findings against Mr. Chauke. Mr. Chauke was not an accused person before Judge Mohoro. That is a problem of fact. He is an accused person for the first time before, might I say, the Nkabinde panel. The second problem that the evidence leader faces is the so-called Hollington rule. Now, the Hollington rule has been subject to a lot of debate in South Africa, but it is still the law. Findings of fact made before an equivalent panel are not admissible or binding in a different panel. Examine the facts that are presented before it. So you cannot have a shortcut. But I'm terribly sorry, some of the evidence was led before Judge Mohoro, and therefore it's conclusive before this panel. Before this panel, there is a fresh duty to present evidence against Mr. Chauke. So, regrettably, for my learned friend, the attempt at relying on the findings of the panel by Judge Mohoro as conclusive evidence before this panel suffers both from a factual and a legal difficulty. 3.1.1.2 is a charge that he recommended, that Mr. Chauke recommended to the then acting National Director of Public Prosecutions. Now again, a charge of recommendation should not be confused with the charge of making a decision. The decision maker has been found to have acted in good faith. The same applies to those persons who recommended. 3.1.1.3 is about seeking to defend the institution of the aforementioned racketeering charges in review proceedings brought by Major General Boyson. Now, Madam Chair, we will also take a similar issue about this being a vague and embarrassing charge that does not disclose an offense. Because what happened is that Mr. Boyson, as an accused person, challenged the decision of the NPA. The NPA is represented by its head, Ms. Jiba, who makes decisions whether or not they must defend legal proceedings. Once she has made those decisions, the junior officials, including Mr. Chauke, ought to give effect to that, including briefing counsel, signing affidavits. It would be a sad day if, when an institution is brought to court in review proceedings, those people who sign the affidavits in good faith are disciplined. It would have been one thing to say that they lied on oath, but there is no allegation that this lied on oath. The mere allegation is the fact of opposing an application. It's being taken to task on that. Then 3.1.1.4 instituted an appeal against the judgment. Now, the evidence that the panel will encounter here is that by the time the judgment of Judge Govan was delivered and the NPA decided to appeal, Ms. Jiva was no longer the acting national director. Mr. Nassan had become the national director.
So the difficulties that the panel will encounter, perhaps it's the difficulty the NPA.
Yes, yes.
So-
Yes. I apologize, Madam Chair. Yes, yes, that's what I'm trying to say. Yes. Thank you for the correction. Yes. Thank you for the correction. Yes. So by this time, there was a new national director, Mr. Nassan. Mr. Nassan, we've consulted with him, and he will give evidence as part and parcel of Mr. Chauke's list of witnesses. Yes, I think it's not Mr. Nassan, I think is an attorney, if I'm not mistaken. Yes. So Mr. Nassan will also be a witness in these proceedings. And he will explain the process that was followed when he got an indication that the senior counsel on brief, that was Mr. Lawrence Hodes, SC, Advocate Lawrence Hodes, SC, had made a recommendation to the prosecutors, which included Mr. Chauke, that there is a basis to lodge an appeal because, in his view, the judge was wrong. A provisional application for leave to appeal was put in on the basis that a request was going to be made to the NDPP. Mr. Chauke was part of that decided that because, as you know this, all of the panelists know, there is a specific time period by which you have to bring an application for leave to appeal. If you don't, you lose the right of appeal. They decided, the group that was working on the matter, which included Mr. Mayema, Advocate Mayema now. Mr. Advocate Mayema will also be a witness that will give evidence in this panel. They decided that the most prudent thing to do is to lodge an application for leave to appeal. Thereafter, to ask the head of the institution, Mr. Nassan, if he decided that he didn't want to appeal, he could withdraw it. But if he decided he wanted to appeal, it would have been irresponsible for them not to interrupt the running of the DS by lodging the leave to appeal. And Madam Chair, this is in circumstances where Mr. Lawrence Hodes, the senior counsel who argued the matter on behalf of the NPA, had advised them that they had a very strong case of appeal. This is really what this is about. We've also spoken to Mr. Hodes. He has agreed to come and give evidence, which is an extraordinary thing for a senior counsel. But that's how strongly he feels about this matter. Now, then, the last of the boys and charges, Madam Chair, is at page 5, paragraph 3.1.1.5.
I beg your pardon, Council, it's Advocate Hodes?
Lawrence Hodes.
Or not?
Yes, Lawrence Hodes, Hodessc. So he is on the list of witnesses to be called by Mr. Chauke. Yes. And so is Advocate Silo Mayema.
Yes, okay.
And just to place him in context, Advocate Silo Mayema was the person appointed by Ms. Jiva to head the team that was dealing with the boys' matter. and among the people that supported him were Mr. Chauke.
And also part of the group that came from the Northwest?
Yes, yes. He was, I think at the time, the DPP of Northwest. Yes, yes. The deputy. The deputy DPP of Northwest. But Mr. Silo Mayema is also a witness that will be called by Mr. Chauke. Then the last of the 5 instances on the Boysen matter is attempted to have racketeering charges against Major General Boysen and members of the K2 unit reinstated by the then National Director of Public Prosecutions, Mr. Nassan, notwithstanding that there was no evidence justifying the institution of racketeering against the accused. Now, the evidence we'll hear about this from both Mr. Mayema and Mr. Nassan is actually a simple thing which we don't understand how it's been elevated to misconduct. What Mr. Nassan told the prosecution team is that he was not satisfied that on the record there was enough evidence to reinstate the racketeering certificate which had been set aside by Government J. They must go and do more, go and dig more before you bring this back to you. Now, they kept coming back to him to say, we think we have more. Both Mr. Mayema was part of that team and Mr. Chauke was part of that team. Kept coming back to him saying, look, we think we have more evidence. Can you please reconsider your decision? And he will say that he kept telling them, no, I'm not satisfied. So what they were doing is they were evaluating and re-evaluating the decision, because the NDPP had taken the view that I don't think this is enough, but if you find more evidence, you can bring it back to me. Now, yes, the evidence of Mr. Chauke, I've been corrected by my junior, would be that he himself was not part of this team that did the reassessment. It was Mr. Mayema who did the reassessment. Now, the important part about this, Madam Chair, is that on the evidence that you will hear, is that Mr. Lasana tells his team that my view is you do not have enough on the racketeering certificate. And I am not going to reinstate the certificate unless you bring me better evidence. They then go back and then come back to him again and say, what about this? What about a different interpretation of the evidence that we have? And then every time he said to them, I'm still not satisfied. And that is why we say, with respect, it is vague and embarrassing in those circumstances to charge somebody for attempting to reinstate the charges. The debate as to the sufficiency of the evidence remained live. But the final decision maker, of course, was Mr. Nassan, and his view prevailed. And that was in the course and scope of prosecutorial discretion. They were working through a decision. So we, again, would like to suggest to the panel that this allegation does not disclose an offense. And when I say it's vague and embarrassing, it doesn't disclose an offense, what I'm trying to say, Madam Chair, is even if you accepted it factually as correct, it would still not amount to misconduct. Then, Madam Chair, I've now done an outline of the defense on the so-called Boysen's matter. Madam Chair, if it is not clear, my junior is reminding me again to stress that Mr. Chauke had no involvement at 3.1.1.5. Then, Madam,
Your junior must give you a break. And then
I-
you do your own. More to present submissions and everything.
indeed, I'm so pleased, Madam Chair, someone has finally seen this. Then, an outline of the second charge. Now, this is the Ndluli case. Now, unlike the first charge, here, Mr. Chauke was the decision maker. We need to look at the charge, and I want to outline what the defense will be. The charge is the failure to continue with charges against Lieutenant General Richard Ndluli for his involvement in the murder of Mr. Tefo Abel Ramogibe, in that he, Advocate Chauke, caused the charge of murder relating to the killing of Mr. Tefo Abel Ramogibe and related charges to be withdrawn.
Council
Or Ramogibe. Thank you for the correction. Yes, unfortunately, they stuck us there in Switzerland, into Johannesburg when we were older. Mr. Tefo Abel Ramogibe and related charges to be withdrawn, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, whose decision caused a significant delay in proceeding with the charges concerned. But here is the point. Mr. Chauke never decided that Mr. Ndluli should never be charged with murder forever and a day in the case of Mr. Ramogibe. Never made that decision. His decision was a provisional withdrawal pending an inquest. That's the first thing. The second thing is, you would have heard yesterday that the evidence leader now intends to run a different case, which is that the decision to refer the matter to an inquest weakened the state's case. But that is not what the president wants an inquiry into. The president has not said anything here about the weakening of the state's case. The president is only concerned about the delay, because he says which decision caused a significant delay in proceeding with the charges concerned. He's not interested in an evaluation of whether the case became stronger or weaker. The problem, though, so Mr. Chauke will, of course, own up that this was his decision, but he will say that this decision was valid and lawful. What I would like to refer the panel to, yesterday you will remember that a lot of time was spent by the evidence leader analyzing the findings of Judge Murphy in a case brought by Freedom Under Law, and all of the criticisms that Judge Murphy had against the decision to refer the matter to an inquest. What is important, however, is that the judgment of Judge Murphy has been overturned. It's no longer the law, completely overturned. The judgment that overturned it is item 2 of the bundle, which is at page 8 to 36. Yes. So the operative judgment right now is the SCA judgment. Anything you hear about what Judge Murphy found is irrelevant. That case has dealt with the issue of Mr. Mdluli specifically, and also dealt with a decision taken by Mr. Chauke to refer the matter charged to an inquest. If I could ask the panel to turn to page 28 of the bundle we've handed up, at paragraph 43. You will see that there the SCA is addressing directly what we are dealing with today, which is the rationality of the withdrawal of the charge. Paragraph 43, it says, this brings me to the decision by Chauke to withdraw the matter and related charges. It will be remembered that on Chauke's version, he withdrew the matter charge pending the outcome of the inquest that he had requested, and that he withdrew the 17 other related charges to avoid a fragmented trial. So the first thing that's crucial here is that Mr. Chauke never decided that Mr. Mdluli will never face matter charges. His decision was a provisional withdrawal pending the outcome of an inquest. That is correctly articulated in the evidence, but incorrectly presented by the evidence leader. The contention by full the judgment continues, was in essence that this decision was irrational. However, as I see it, the contention has not been substantiated in argument. On the face of it, the decision that the findings at an inquest could perhaps enable him to take a more informed view of the prospects of the state's case with regard to the matter charge was not irrational. So they're answering the question, was it irrational? They say no, it was not irrational. It's a different way of simply saying double negatives was rational. It is true that the outcome of the inquest could have no impact on the related charges. Mdluli, as a member, there was murder, but there were many other charges, 18 in total. But Chauke never thought that it would. As I understand his reasoning, he always intended to reinstate at least some of the charges after the inquest, with or without the charge, and discuss that. Really, the evidence leader has the wrong end of the stick, because there was never a decision that Mr. Mdluli will never be charged with murder. If the inquest suggested that he should be charged with murder, he would have been charged with murder. That's what the SCA reported. What he tried to avoid, the SCA continues, so he said, was a fragmentation of trials. That line of reasoning, I do not find irrational either, particularly since the evidence supporting the related charges would also impact on the murder charge. It is true that he could have asked for a postponement of the 17 related charges pending the inquest, but we know that a postponement is not there for the asking. It could be successfully opposed by Mdluli, in which the fragmentation which Chauke sought to understand may have become a reality. So that's in paragraph 43. And I would like to also ask the panel to have regards to paragraph 45. It's very important on the evidence. And I'll explain shortly why it's important on the evidence that will be there.
Counsel, if you may pause there, just for clarity in relation to the referral for an inquest. I beg your pardon. Yes, sir. I beg your pardon. Just for my clarity, the referral for an inquest related only to the murder charge.
Yes.
And the
17 other charges.
ancillary charges What happened to them?
They
Were
were
they
postponed.
proceeded with?
No, they were postponed.
They were postponed,
Postponed, yes.
pending the.
They were withdrawn pending the outcome of the inquest. They did not say postponed.
They were withdrawn,
yes.
pending the
Outcome of the
outcomes of the inquest.
Yes, yes. In fact, Madam Chair, I thought there's somewhere in this judgment where that I think when that point is made, I just can't remember now where. Oh yes, Madam Chair, it is actually at paragraph 43. In the second line, and the second sentence as well, it says, it will be remembered that on Chauke's version, he withdrew the murder charge pending the outcome of the inquest that he had requested, and that he withdrew the 17 other related charges to avoid the fragmented trial. Yes. Thank you, Madam Chair. That's where it's got. Yes. And the next part that we would be relying on in the case of Mr. Chauke is paragraph 45. Now, this is what is said in paragraph 45. However, having said that, senior counsel for the NDPP considered, rightly and fairly in my view, that there is no answer to the proposition that at least some of the murder and related charges are bound to be reinstated. In the light of this concession, he undertook on behalf of his client, which undertaking was subsequently elaborated upon in writing. A, that the NDPP will take a decision as to which of the 18 charges are to be reinstated and will inform full of that decision within a period of 2 months from this order. B, if the NDPP decides not to institute all the 18 charges, he will provide full with his reasons for that decision during the same period. I cannot see a reason why this undertaking should not be incorporated in the court's order, and I propose to do so. If you then turn to the order itself, which you will find at paragraph, at page 34, at paragraph 54 of the judgment and subparagraph 3 of the order, it is stated, it is recorded that the following undertaking has been furnished on behalf of the first respondent. The first respondent is the NDPP, not Mr. Chauke, to decide which of the criminal charges of murder and related crimes that were withdrawn on 2 February 2012 are to be reinstituted, and to make his decision known to the respondent within 2 months of this order. The respondent in that case was Freedom Underground. At page 35, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some, if any, of those charges. Now, the reason why this is an important element in the case is that after this judgment was delivered, the decision whether to charge Mr. Nduli or not was no longer the decision of Mr. Chauke. It was the decision of the NDPP. At that point, the NDPP was Mr. Nasser. He decided not to charge Mr. Nduli with murder. And he wrote a letter to that effect to Freedom Underground, as per the court order. And this is why we say that it seems that there is a mental confusion about what decisions were made by Mr. Chauke and what decisions were made by his bosses. The only decision Mr. Chauke made was a decision to refer the matter to an inquest. And thereafter, a decision will be made. That decision has been found to be valid by the Supreme Court of Appeal. But the question of the reinstatement, which accounts for the second part of this, so if you look at the charge, where it says which decision caused a significant delay in proceeding with the charges concerned, the SCA has already found that Mr. Chauke's rationale, which is to avoid a fragmentation of trials, was logical. But the SCA took the decision from Mr. Chauke and placed it in the hands of the NDPP, So the NDPP's decision, and you will hear the evidence because the subsequent NDPP, Mr. Masana, will be giving evidence here. He will confirm that it was his decision after the SA's judgment not to reinstate those trusts. And full, in fact, did not challenge the decision by Mr. Masana. Madam Chair, I'm told that it's already 18 minutes past 11. So perhaps this will be the continental.
Yes, I think it is, I think that as our agreement earlier, we will take a tea break of 15 minutes. When we reconvene, Advocate Andrew, as you pause, I would like you also to look at the words used in paragraph 3.1, page 3 of the Bible, in the terms of reference. His, I'm quoting there, his direct or indirect conduct. Those words. We may also deal with that when we reconvene, or maybe even at the end of your presentation, so that I don't delay you from the course. We will take 15 minutes tea adjournment, meaning that we will reconvene at about 25:02. Thank you, Mulachen.
Thank you. Thank you very much. I know. No, hello, you.
How are you, brother?
I'm fine.
Why are you sabotaging us?
I'm not sabotaging.
You are. Did he tell you that he gave us a lucky that doesn't work? Oh wait, you got to see it, right? See, Tabo and Mahomu,
It's nice to
Jasmine.
have a good relationship with God. They knew Rocket Max was involved and they had to save the
No,
situation.
they saw a journalist that was about to crime and
Shame, you wanted to cry.
and I was like, oh my god, I want to work so hard.
And you know what I tell you? I've told all my colleagues that if you're in Victoria, just call me.
But I don't understand. That's why they're giving us a live view for an inquiry. This happened yesterday. It happened today as well. That's super Kamala. That's it.
Oh, like London.
If you were still
It's the second. Yesterday we had an issue. It's coming up. This is Saturday. It's again. It's the same thing. Why else the reason?
no, it's not personal.
I think it's personal. When?
No, no, no. Yay. Remember those supposed to shoot us until there's. Yes, yes. I feel like we just have tea. Why do we have an hour after tea? That's literally an hour after tea. It doesn't say
And it will be 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. The audio is clean. Happiness. Testing the audio. 1, 2, 3. Testing the audio.
I will let you check out the feed because they want more. It's found wanting. It's not bright enough. Go home, wherever sharp, more it gets consumed. Yes.
Me, it is a good light. Independent, yeah, it's a high school level. It was too much of that stuff.
That's fun. Yeah, I don't have.
Stuff. He was like, Sawati ba? Oh, okay. Yeah, in the first school, very deep. Deep. Kimsadi bono, asamu ya guys. Kila
Yes, thank you, Advocate Nkabinde.
Thank you, Madam Chair. Madam Chair, I'm still continuing the analysis of the Mdluli case, Mr. Mdluli case. There is one aspect from the SCA judgment which is important because it places in context the statement that was made yesterday by the evidence leader. You'll find that at page 29, paragraph 44. And the panel will recall that what paragraph 183 of the judgment of Murphy J was relied upon in express terms yesterday as one of the points of criticism against the decision of Mr. Chauke. And you will recall that when I began this line, I pointed out that that judgment of Judge Murphy has been overturned. Paragraph 44 of the SCA judgment says the following about paragraph 183. It says, Fool's real argument, which found favor with the court a quo, paragraph 183, is that Chauke's failure to proceed with the murder and related charges after the findings of the inquest became available was irrational. But that decision, or really his failure to apply his mind afresh to the matter after the conclusion of the inquest, was not the subject of the review application. It will be remembered that the review application started in May 2012, while the results of the inquest only became available in November of that year. Stated somewhat more concisely, I do not believe the earlier decision to withdraw the charges, which is the impugned decision, can be set aside on the basis that a subsequent decision, taken in different circumstances, not to reinstate or some of those charges, was not justified. To that extent, the appeal must therefore succeed. You will recall that that was the appeal of the NDPP, among others, against the findings made in paragraph 183. Those findings were expressly set aside. So when you try to compare this with...
Counsel, I beg your pardon.
Yes.
I think we must correct your statement that Murphy J's decision was overturned.
Yes.
I think when you look at the order, it was partly upheld.
Yes.
If you look at the order itself.
Yes.
So we need to focus on those areas of the judgment in respect of which Murphy was overturned and in respect of which he was not. Because if you look at paragraph 1 of the order,
Yes.
in the premises, it is ordered that the appeal succeeds only to the extent that paragraphs of the order of the Kodako are set aside.
Yes.
What I'm saying is that your earlier statement to suggest that Murphy's decision, the whole judgment was overturned. So we need to focus, and if you can direct us to those areas of Murphy J's judgment or paragraph or decisions
Yes.
that were overturned in respect of the terms of reference.
Yes. Thank you, Madam Chair.
So that, because it can be misleading the way you put it earlier.
Yes. No, I accept that entirely. I think the point really is this. Insofar as it was, yes, perhaps that is them presenting it. Yes. And that you find at paragraph 43, 44, and 45. And then if you compare that then with the, with charge 3.1.2 at page 5, which is the decision to refer the matter to an inquest. And that you will find at 3.12 of the charge, where they say, caused the charge of murder relating to the killing of Mr. Tifo Abel Ramokhebe and related charges to be withdrawn, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter. Now, that withdrawal decision by Judge Murphy was overturned. And then the later part of that charge, which says the decision caused a significant delay in proceeding with the charges concerned. Now, again, that criticism by Judge Murphy was overturned in paragraph 45. Yes. Thank you, Madam Chair, for the correction. I stand corrected. Yes.
Thank you, Counsel.
Yes. Then I've completed the analysis of the charge by reference to the judgment of the SCA, and we will be making reliance on the judgment of the SCA. Then, Madam Chair, I referred in my earlier address to the standard that must be applied in where a prosecutor is charged specifically with the exercise of prosecutorial discretion. Might I refer the panel to page 101 of the bundle we handed up? Now, the panel doesn't have to necessarily read that for now, simply to say that this is the extract from the finding of the Ginwala Commission. And the panel will recall that that was an inquiry into the conduct of Mr. Pikoli. It's ultimately turned out, it's known now to be the Simelane inquiry, but it was actually against Advocate Pikoli. But paragraph 101 said something salutary, which is also at page 101. Where it says the following: I must also point out that this complaint comes very close to trespassing on the terrain that the legislature and the Constitution has reserved for the discretion of the NDPP. It would not be proper for anyone to second guess the judgment of the NDPP without encroaching on the constitutionally guaranteed independence of the NPA. The decision to prosecute or not to prosecute the 11 mercenaries, or to conclude or not to conclude a plea and sentence agreement, is one which the Constitution says the NPA must take without fear, favor, or prejudice. The legislation governing the judicial review of administrative actions and decisions specifically exempts a decision to prosecute or not to prosecute from judicial review. Now, why that is relevant here is because one of the allegations against Advocate Pikoli was that he made decisions to enter into plea agreements in circumstances where there was an overwhelming case against some persons alleged for mercenary activity. The Ginwala Commission is salutary because it says that decision, whether to charge or not to charge, is a matter that the legislature preserves for the prosecutor concerned. Now, that we will submit in due course, and we will support it with the evidence of Mr. Harinel, who will explain the intricacies involved and the difficulties involved when prosecutors make decisions. And that's why we think it's necessary to set this up front right now. I also referred, Madam Chair, to the decision of Judge Mohoro and her panel, but I didn't take you to the specific part. She also dealt with the question of Ms. Jiba. And one of the advantages that she had was that she already had all of the judgments that I have been referring to. The distinction that she draws, the panel will find she draws, is at page 104 of the bundle that we handed up, at paragraph 1062. And this is what they confirmed. 1062, page 104. Jiba's counsel quite correctly pointed out that in the SCA's assessment of the facts, no case of misconduct could be established against her. The court supported the GCB High Court's findings that no mala fide or ulterior motive could be shown in Jiba's authorization as contemplated in POCA. In relation to the delays in the full matter, that's the Mdluli matter, the court explained that Jiba may have been a trained lawyer, but her opinion would have been secondary to that of her counsel and of LAD. Differences of opinion in relation to the Halgane memo, which could not be said to have established that Jiba was not fit and proper to remain on the role of advocates, simply because she had been advised otherwise. So she accepts all of those findings, but here is where she draws a distinction. This, of course, must be distinguished from the fit and proper evaluation as it applies to NPA officials. The SCA acknowledged as much, explaining that an inference regarding her incompetence with regards to her duties as DNDPP may be inferred, which would then be a ground for her to be removed from her position of DNDPP, Deputy National Director of Public Prosecution. It seems that the case, we would have to get a full record, against Ms. Jiba was a case, you remember, Madam Chair, we spoke at the beginning of gross incompetence. Yes. Now, we don't have a case of gross incompetence against Mr. Chauke. Then, Madam Chair, I've now done an analysis of those charges, looking at the judicial outcomes. I want to say a few things then about the actual decision. Starting with the Boysen matter, the panel will recall what this case is about a series of abuses by police officials who were part and parcel of the Cato Manor squad or Cato Manor team or Cato Manor unit. Is referred to in various appellations. At a certain point in time, Mr. Boysen was the head of that unit. When the racketeering certificate was signed, Mr. Boysen had moved from that unit to be the head of DPCI in KwaZulu-Natal at the provincial level. The case involved more than 20 dockets. Some accounts say 23 dockets, other accounts say 26 dockets. The pattern in those dockets is that police officials would follow a purported suspect. Instead of detaining them as the Constitution requires, they would make a decision to execute them. Mr. Boysen was aware of that pattern of execution of suspects. In some instances, he was present at the site of the killing. In some instances, he expressly authorized certain of the activities of the police officials. The question that arose, which faced the NPA, was, is there sufficient evidence to show, firstly, that the predicate offenses were committed, and secondly, whether Mr. Boysen was involved in any manner, shape, or form to justify the institution of a racketeering charge against him. And as the panel knows, a racketeering charge depends on the predicate offenses.
Counsel, I do appreciate that at this juncture, you are giving us just an overview,
outline, yes.
An outline, but we'll later draw our attention to those instructions,
yes,
or authorizations that he seemingly gave,
yes,
at the scene when
yes,
he was present.
Yes. Now, So the first element of the so-called racketeering is there must be offenses, criminal offenses. The question really in this case was not the presence or absence of the predicate offenses. Just to take two of those examples, Madam Chair, the example of Mr. Bongani Mkhize. Mr. Bongani Mkhize had obtained an interdict against the police, which included Mr. Boysen as a respondent, in which he said, if you want to detain me or arrest me, I'll hand myself in. There is no need to intimidate me, to violate me. In fact, there was an interdict against shooting him. He was subsequently murdered, and by all accounts, by members of the Ketumano unit. And they had strategies of planting weapons after the killing of a suspect and making it as if the murdered person was the aggressor. They were acting in self-defense. Or take another extreme case, the case of Kwazi Ndlovu. Kwazi was a 15-year-old boy, found at home in the evening, taken out, executed, and then a gun placed on his hands. The police faced no threat. They had no basis to use violence against him. But nevertheless, they executed him. And the evidence was clear that the killers were part and parcel of police officials linked to the Ketumano squad, or the Ketumano team, or the Ketumano unit. When these allegations were made to Advocate Jiba, she did not want to make a decision herself. She put together a team. Mr. Silo Mayema was the head of that team. Mr. Chauke was a member of that team. There were also people from the DPCI, police officials from the DPCI. So you can describe it as a multidisciplinary team. And there were also people from IPID, the Independent Police Investigative Directorate. So you can describe it as a multidisciplinary team. They conducted a thorough assessment of the statements that were contained by witnesses. Of those statements, 3 stood out. And I'm coming now, Madam Chair, to the question you asked about the source material. Of those statements, 3 stood out. And the reason they stood out is because they were given by persons who were part and parcel of the unit. Those statements directly mentioned Mr. Boysen. Although they admitted that Mr. Boysen at that point was no longer formally the head of the unit, they nevertheless stated that he was de facto in control of the unit. One of those statements, and you will see the criticism in the judgment of the KwaZulu-Natal High Court by Judge Govan, was not signed, and it was submitted by a gentleman known as Danikas, who was a police reservist. At the time of the signing of the certificate, it was not yet signed. But that entire technical issue was dealt with thoroughly by Judge Lehodi, who pointed out, Madam Chair, that Section 2, subsection 2 of POCA allows a court to admit all types of evidence, information, documents, hearsay statements, similar fact evidence. And then he said, if that information is admissible before a judge, it stands to reason that it would be admissible before the NPA. When the NPA assessed the evidence, it took the view that the statement of Mr. Danikas was admissible. We will show you that the statement was subsequently signed, and it confirms in all material respects the version that would have been given by Mr. Danikas. Another statement that stood out was a statement by Mr. Dlodlo. Statement was written in Zulu, who also directly implicated Mr. Boysens. There was also common cause evidence that the members of the Ketomano unit received a thank you gift for their activities of 10,000 rands per member. Mr. Boysen himself received, I think, 10,000 rands as well. There was also the statement of Mr. Ayer. Mr. Ayer had taken over from Mr. Boysen. He also directly implicated Mr. Boysen. The comparison, Madam Chair, between Judge Govan and Judge Lekhodi in terms of the statements that were present, you will see between paragraphs 55 and 67 of the GCB versus Jiba case, where Judge Lekhodi goes extensively to analyze each statement and each contents of the statements and how they ultimately put Mr. Boysen on the scene. Now, this panel, we will not ask the panel to say Mr. Boysen is prima facie guilty or not, but we will ask the panel to find that on the evidence that was before them, it was entirely justifiable to say that enough of a case exists to sign a racketeering certificate. Madam Chair, you'll remember that what my client is accused of is supporting, recommending, seeking to defend, instituting. But the key of each of those charges are the following words: notwithstanding that there was no evidence justifying the decision. That's the key to all of them. It's the words, notwithstanding that there was no evidence justifying the decision. There are two things that the panel needs to be considerate of when it listens to the evidence. The charge is that there was no evidence. The charge is not that the evidence that was present was insufficient. Yet it is common cause that there was evidence. That's the second part. The debate among the prosecutors was whether that evidence is enough or not. The view that was taken by Advocate Jiba on the advice, we will not shy away from it. Mr. Chauke was one of the persons who supported the decision. He was one of the persons who recommended the decision. Of course, he was a part and parcel of the team. But the decision maker was Ms. Jiba, and the view that Ms. Jiba took at the time was that she was satisfied about the evidence. That was not the view that was held by Mr. Ngasana. Mr. Ngasana was not satisfied. But both of those decisions are capable of living alongside each other with both of the parties acting rationally and bona fide. You don't go and charge Mr. Ngasana because his opinion was that the evidence is not enough. And you don't charge Mr. Chauke on the basis that your recommendation was not based on good enough evidence. But you will have to ask yourself whether or not the evidence leader can substantiate the statement that there was no evidence. And we will show you that that statement cannot be substantiated. There was evidence. The evidence was sufficient. We will obviously not say that the evidence was conclusive, because that was not required at that stage.
In any event, I cannot imagine that in a criminal setup you can safely say the evidence is conclusive.
Yes, until
As a prosecutor.
Yes.
Until the judge or the magistrate decides.
Until the magistrate decides, yes. Yes. Now, on this point, Madam Chair, you will see in the prosecution policy, which is referred to in the charge sheet, the prosecution policy requires prosecutors to evaluate the case and the evidence until the last minute. And it appreciates that when they start a prosecution, they may take a particular view, maybe robust, maybe conservative. But as the developments go along, representations are made, witnesses that initially appeared to be reliable turn out not to be reliable. Witnesses that initially agreed to testify refuse to testify. The key on that prosecutorial policy is that a prosecutor must always be agile and able to evaluate their position until the end. And it allows them, where they initially charge a person, to also withdraw the charge when new evidence emerges. That is a good thing, Madam Chair, which unshackles prosecutors to do the job that we are paying them to do. It is really a bad thing that when a prosecutor made one decision, they must be taken to a disciplinary hearing. I went through, Madam Chair, cases in preparation for this statement, cases of malicious prosecution. They are a legion. But I would be shocked that in all of the cases that I've read about malicious prosecution, those prosecutors have been taken to a disciplinary hearing. This is why then, Madam Chair, this multidisciplinary team prepared a memorandum and gave it to Ms. Jiba. When, and this is now dealing with the defense 3.1.3, when there was a review brought by Mr. Boysons, what the prosecution team did, it went to a senior counsel, widely respected for his expertise in criminal law, Mr. Hoddes. They asked him, Mr. Hoddes, tell us your opinion. Is this good enough, or are we barking the wrong tree? He told them, you have a strong case, defend it. They defended it. When they lost the case, they still went back to him, which is now in 3.1.1.4 on the appeal. When they lost the case, and we will show you the memorandums that he prepared, they went back to him, said, Mr. Hoddes, you initially told us we had a good case. We've now lost the case. Should we appeal? He says, yes, you should appeal. On the strength of that, they filed an appeal. Just think about this. And then today we're having a person who is hauled before a disciplinary hearing. You know, there's a word constitutional lawyers like, chilling effect. This has a chilling effect on prosecutors. I make one wrong decision, I will actually one day face a disciplinary inquiry. On 3.1.1.5, I've already explained that the basic defense there is that that decision was just not made by Mr. Chauke at all. He was not involved in that at all. And I've already outlined the defense on the Mdluli case. Having said this, I must tell you about who is this man that we are dealing with today, Mr. Chauke. It's been written up for me, Madam Chair, so I'm looking for it. Where is it? Oh, yes.
As you reflect,
Yeah.
I am tempted to say, what was the role of Advocate Chauke in the Katomena matter?
Yes.
I'm saying I'm tempted because it is not you who brought this matter here.
Yes.
I suppose someone will present that case
Yes.
and then you will respond. So I will withdraw my temptation.
Thank you, Madam Chair.
You may proceed.
Madam Chair, I referred to the prosecution policy and particularly the need for flexibility.
If I may, Counsel, I beg your pardon. Just to recap, the signature of the racketeering authorization was done by Advocate Jiba.
Chiba, yes.
Yes, thank you.
Yes, thank you. Yes, the prosecution policy dated June 2013 says the following. In fact, it's very helpful to remember this. It says, in deciding whether or not to institute criminal proceedings against an accused person, prosecutors must assess whether there is sufficient and admissible evidence to provide a reasonable prospect of a successful prosecution. There must indeed be a reasonable prospect of a conviction, otherwise the prosecution should not be commenced or continued. This assessment may be difficult because, and this is the point, Madam Chair, you made, it is never certain whether or not a prosecution will succeed. In borderline cases, prosecutors should probe deeper than the surface of written statements. Where the prospects of success are difficult to assess, prosecutors must consult with prospective witnesses in order to evaluate their reliability. The version of the defense of an accused person must be considered before a decision is made. The test of a reasonable prospect must be applied objectively after careful deliberation to avoid an unjustified prosecution. However, prosecutors should not make unfounded assumptions about potential credibility of witnesses. Then it says the review of a case is a continuing process. Prosecutors must take into account changing circumstances and fresh facts which may come to light after an initial decision to prosecute or not to prosecute has been made. This may occur after having heard and considered the version of an accused person and representations made on his or her behalf. Prosecutors may therefore withdraw charges before an accused person has pleaded, in spite of an initial decision to institute a prosecution. So that comes back to this thing that this is a continuous process. You look at the evidence you have at that stage, you convince yourself that it is sufficient and it is admissible. New evidence then emerges. You are obliged to continue evaluating that case. What you never do, you never say, I am now charging you with misconduct because on a certain date you made a decision to charge a certain person, because that is just against the prosecution policy. Now, Madam Chair, I wanted to, before coming to answer the question you asked me before the adjournment, to just give you a sense of who are we dealing with.
Before you go there, Counsel, it just occurred to me as you were addressing the last aspect about the fragility of that process.
Yes.
It's ongoing.
Yes.
Where does it end? Doesn't it end even probably at the end of the entire case?
Yes.
Or first, probably at 174?
Yes.
If not, at the end of the entire case.
Yes.
That fragility.
Yes.
If that is the case, can a prosecutor then be faulted
Yes.
for having let the case run until
Yes.
Section 174?
Yes. We submit with the greatest respect. This is why we describe these charges as dangerous charges. Because we would submit, it's not misconduct for a prosecutor to run a case that they subsequently lose. It would have been a different issue if the charge sheet said, Mr. Chauke took money from a witness in order to proceed, because that would be corruption, or that he acted mala fide. What is striking about the charges is that there is no allegation of dishonesty or malice, which means he was bona fide throughout.
Thank you for answering.
Thank you, Madam Chair. So who is this man? Mr. Chauke has served the administration of justice for...
Before you go to who is this man, you were going to look at that 3.1,
Yes,
the direct
yes.
or the indirect.
Yes.
Are you going there?
I can do it now. I was going to do it after this, but I can do it now.
No, you may. I don't
Yes.
want to disrupt
Yes. All right.
the
Thank you, Madam
structure
Chair.
of
Yes.
your presentation.
Yes. Thank you, Madam Chair. Mr. Chauke has served the administration of justice in this country for more than 40 years. He has risen through the prosecutorial system by diligence, competence, integrity. He's never been found wanting on any of those matrices. He began in 1983 as an interpreter in the Guyana Magistrates Court. He completed a diploma juris in 1988 and thereafter was appointed as a prosecutor. From the outset of his career, he was entrusted not only with prosecutorial decisions, but with training new clerks, interpreters, junior prosecutors. This was a sign of confidence placed on him at an early stage. After completing his B. Juris and LLB degrees while he was working full-time, he was promoted to prosecute in the regional court and later served as a magistrate after completing the magistrate's civil seminar at Justice College. In 1996, he became the first African senior prosecutor in the Randburg region. In a sense, this is a momentous occasion that the first African prosecutor in the Randburg region is today being called in a misconduct inquiry. In that role of managing 19 prosecutors, overseeing all district and regional courts in Randburg, Wynberg, Midrand, he was responsible for supervision, training, docket preparation, media engagement, and representing the DPP in stakeholder forums. His responsibilities increased when he was transferred to the office of the DPP in the then Witwatersrand local division, where he prosecuted high court trials and appeals, prepared indictments, and vetted the work of junior advocates. From 2001 to 2004, he served as the chief prosecutor of the Vaal Triangle cluster, where he managed 10 offices with extensive administrative, financial, and oversight responsibilities, including PFMA compliance, performance monitoring, liaison with SAPS and local authorities, and the overall functioning of the cluster. He later completed a diploma in corporate governance and was appointed as the regional head of the Special Commercial Crimes Unit in Johannesburg, leading a team specializing in complex fraud and corruption prosecution, and contributing to the Dornan Commission of Inquiry into the Oil for Food program. In 2007, he joined the Johannesburg Bar. He practiced across civil, labor, criminal, and equality matters, and interacted with senior officials in both the public and private sectors. On 1 September 2011, he was appointed as the Director of Public Prosecutions, South Gauteng, where he was, until his suspension, responsible for 400 prosecutors and 100 support staff. In this capacity, he has overseen prosecutions of some of the most prominent matters, represented the NPA in high-level engagements, and managed one of the busiest prosecutorial offices in the Republic. One of the witnesses that will be called, Madam Chair, Mr. Kherinel, will testify not only about his interaction with Mr. Chauke when he was in the NPA, but after he left, and the level of professionalism that he has always encountered whenever he dealt with Mr. Chauke. So we say that this is the professional and the personal account of Mr. Chauke, a prosecutor, a magistrate, a senior manager, an investigator, a practicing advocate, and ultimately the DPP of this province. This is a record of steady advancement, deep institutional experience, and decades of commitment to the administration of justice. Nothing in this career has shown or suggested a person prone to recklessness, to malafide, or the disregard for the rule of law. To the contrary, his history is one of sustained public service and trusted leadership. We ask that you take that into account in listening to the evidence that will be laid, which will attempt to portray him as something that he is not. When I then finalize, Madam Chair, to look at the specific point in 3 point, well, it starts at 3. Well, it starts at 2. It says,
Let me say this. I think it, in all fairness, you should probably wait
yes,
and not answer that question because someone will explain better
yes,
those concepts.
yes,
I will be unfair to you to expect you to elaborate on these terms of reference
yes.
as I was doing. I think we will wait for Advocate Batoyi to assist us to understand that those concepts, and then you'll take it from there.
As you please, Madam Chair. I'm happy not to disagree. Thank you, Madam Chair. I've got nothing else to add.
I suppose you're going to hand up the written opening address at some stage.
Yes, it will be handed up shortly, literally in the next hour. Yes, it will be distributed on email.
On email.
Yes.
Yes, thank you. Thank you, Council. My sister just reminded me of something. You revert us to a number of witnesses that you intend to call.
Yes.
And needless to say, at one stage, those statements should be made available to us. But I say this guardedly, knowing that things have not happened as swift as things should have happened, given the circumstances of this case. There has been some delays, and there has not been a proper communication with the evidence leader, meaning that, or rather resulting in delays in presenting documentation, not only to you, but also to the panel. I would like to know
from you, when do you propose to be ready with those statements? We will proceed from the evidence leader side. Their bundles are ready. That should not delay the inquiry. You have a team of able lawyers next to you. As you proceed, they can go and consult to fast track the process rather than postponing and you go and sit with witnesses. So as it happens with the evidence leading team, whilst they proceed, one of his colleagues will deal with other outstanding matters. I'm saying this because we have run behind schedule, 1.5 months behind schedule. And I suppose that we all share the sentiments that this is not a matter that should delay any further. Nobody wants to be subjected to this kind of uncertainty. And I'm sure Mr. Chauke, as I read in some of his written representation to the president, he said he's ready to start. And I understand why he would want this matter to be finalized as soon as possible. So the long and short of this long prelude to my question is it feasible that your team can start working on taking statements from those witnesses that you'd like to call, just to fast track the process and not delay it any further? Is that possible?
Madam Chair, you will be pleased to know that we've substantially revised our position. We think that we should be able to match the panel's desire for expedition. So we can work on statements and literally deliver them not next week, but the week after. So we are not going to ask for long delays, no. So if you are asking me for a specific date, I could, oh yes, that's actually very, very important. I'd forgotten about it. The 3 witnesses, Mr. Kharinel, Mr. Ngasana, and Mr. Silomayema, are ex-NPA. There is a provision in the NPA Act that they may not disclose information obtained by them in the course and scope of their duties without permission. Last Wednesday, we wrote a letter to the NPA telling them that we had consulted with these witnesses. And in the course of the consultation, one of those witnesses raised the concern that the Section 41 subsection C prohibits them from disclosing information to us, and that they need authorization from the NPA. That letter was written on the 14th of November. That's Thursday, not Wednesday. 14th of November. We have not received a response. So we would be very keen to get those authorizations so that those witnesses can sign statements. On the
Has that letter been copied to the Secretary of the Inquiry?
I'm told yes.
On the 14th.
14th of November, yes.
And I suppose that Advocate Munyani has had a sight of it as well?
Yes, I'm told he has.
May I just confer with Council? Yes, sir. I'm sorry. I do forget that I have to speak to this microphone. Advocate Munyani, have you had a sight of the letter of the 14th to the NPA requesting authorization, the disclosure.
Madam Chair, I recall discussing the issue with Advocate Patohi. I can't recall whether I saw the letter or not, but such request was made to the NPA. And I believe if she has not signed it yet, already, she is going to sign the authorization in terms of Section 41(6) of the NPA Act.
Well, the 14th Advocate Nkabinde was on Friday, just last Friday.
Yes,
Yes.
indeed.
It may well be that the NPA is looking into the matter. And as you'd have seen on television, she's been busy elsewhere. So let's hope that the authorization will be done. I suppose, Advocate Halley, you can probably assist there, maybe speak to the NPA to facilitate that request.
Indeed,
Whether
Chair.
yes or no, I don't know what you people do, but the request is pending.
I understand that the request has been acceded to. It may simply be that the written communication thereof hasn't yet been transmitted.
We can only note what you are presenting before us. I do understand, Council, that the delay in the authorization will have an effect on the consultations, effectiveness of the consultation with Advocate Nell, Advocate Maema, and Advocate Mr. Nwasana.
Yes.
I think what we are discussing now is sufficient to remind all concerned of the importance of reacting to that request.
Yes. Thank you, Madam Chair. So subject to that, these are all senior practitioners. They are also helping us to draft their own statements. So it is not a scenario of dealing with a lay witness where you have to draft the statements.
Yes.
So we can make it quicker than it would ordinarily be the case. And I was thinking that it should be feasible to complete the statements of these witnesses by the 1st of December and to hand them to the panel. I'm glad we are on this topic, Madam Chair, because I've been looking for the right opportunity to raise the wider problem that you have seen that this case in large part depends on 2 dockets and 2 records. The Mdluli docket and the Boyson docket. The charge itself, if you look at charge 3.1.1.1, talks about the docket in the Boyson matter. Now, there is also the Jiba judgment and as well as the full judgment. We had asked as early as the 7th of November for the full records in those cases. We have not received them. They themselves are relying on statements made by the judges in those cases, but we don't have the records of those cases. So that also does implicate the preparation time that we would need. They know the letter, they've received it, but perhaps they can commit now to giving it to us with a date. Thank you, Madam Chair.
Mr. Ramuhali, we are still doing the preliminaries. In fairness to the senior counsel, you just give him space. Some of the matters you can discuss when we adjourn. You still have abundance of time to have your conferences there. I suppose the appropriate thing to do in the circumstances when we adjourn is for all the teams to come together and address these issues. We cannot decide for you unless if there's a substantive application for us to make an order or direction. But some of these things can be dealt with by way of agreement when lawyers sit and talk. When should you expect the authorization, for instance? When do you propose to be ready with the statements, that is the filing thereof? When will you be provided with the paragraph 3.1.1.1 dockets and all other documents? We will not be able to assist you unless you approach us properly so that you can compel somebody to do what they are supposed to do if it is necessary. My suggestion is that when we adjourn, and probably the entire afternoon, if we are not going to proceed with Advocate Batohi, you may use that opportunity to address these aspects, because we cannot delay that. You can deal with that maybe for an hour or so and come up with an agreement that will be made an order or the panel's direction. Then we can take it from there. May I just confer with my sisters on that? We are so minded to do as I've proposed, that we're going to take a lunch break, and after you have had lunch, you can take time, an hour or so, and if you need more time, you can approach us and see if you can deal with all these issues to fast track the process. Because if you can't have those statements, it means we cannot proceed at a later stage. It may well be that those very dockets that you have asked for may be helpful to the evidence leader as well. So discuss those aspects, and if you can't reach an agreement, you know what to do. Anything else, Advocate Nkabinde?
Nothing, Madam Chair. I will not tell you what Mr. Ramuhali wanted me to say.
I'm not going to be privy to those conferences. I've warned him several times. Probably I must chuck him out of the premises. The evidence leading team, because I've been addressing you, especially with regard to the processes relating to the sharing of documents. Do you anticipate any challenges in respect of agreeing? I'm sure somebody from the NPA is here.
Yes,
apart
Madam
from
Chair.
council.
Apart from council,
Who is here?
there is an official from the NPA who is here with Advocate Batohi.
I don't see Advocate Batohi here.
She's sitting.
Is she in the holding room?
Yes,
Yes,
she's
thank you.
sitting there.
And the official, is the official here? Okay, thank you.
She's also sitting with her, Madam
Yes, thank you.
Chair. Thanks.
Let me will apologize to her for just holding on, because it seems to me that it is critical that we get this process running to make sure that you agree on the sharing of documents, the request for authorization, for instance, the statements, the dates for statements. Well, once you get the undertaking that the authorization will be provided today or tomorrow, you'll be in a position to say the statements will be ready by the 30th of this month or the 1st of December. And the wider problem with regard to the dockets, etc., discuss it amongst yourself and see if you will be able to come to Nadering, the LSA. Is that Nadering, African-speaking people? Maybe you'll come closer to each other, to one another, and then write a document in a form of an agreement that we may endorse. When you are ready, you will let us know.
Thank you, Madam Chair.
Will that be possible?
That will be possible, Madam Chair. Thank you. I don't foresee any problems in having discussions with our learned colleagues. I think in due course, we'll be able to see eye to eye as far as taking the matter forward is concerned. We will try our best to expedite the serving of requested documents on the Chauke team. Thank you, Madam Chair.
Confer, you may.
Thank you, Madam Chair.
It is okay to give an embrace. Remember, it said the lunch will be.
Thanks, Madam Chair. Thank you, Madam Chair. I've conferred with my learned colleague and with Advocate Harley for the NPA. We can adjourn at this stage to have the conversation with our colleagues.
I think your lunch is ready. I'm serving lunch, so after lunch, 30 minutes lunch, you can then have your discussion. And as soon as you are ready, let us know.
We'll do that, Madam Chair.
We adjourn. Thank you.
Thank you.